and I want to warmly welcome our esteemed moderator and speakers for our next panel, panel 4. We have a moderator, Professor Walter E. Dellinger III, who is both a Professor Emeritus of Law at Duke University and a former Solicitor General. And we have our panelists, Dean Mario Barnes, former Dean Rachel Moran, and former Solicitor General Seth Waxman. They will be talking about the contemporary legal battlefield spotlighting affirmative action in higher education. Professor Dellinger.
Good morning, and thank you so much. I don't recall anything about my 13th birthday. It was celebrated on a Saturday in May, but I will never forget the following Monday. It was just after my 7th period class when there was at the classroom door and a hushed conversation between our teacher and the assistant principal. In my mind's eye, I see our teacher turning very slowly to come back in the class, so much so that I remember that the 7th grade chatter, the 7th grader, the chatter of the 7th grade fell to a hush because we saw how the gravity on our teacher's face. And I know I can recall the exact words of our teacher who said, "Children, the Supreme Court has spoken. Next year, you will go to school with colored children." I remember looking at each other, what kind of world is this? Well, of course, and I thought back on that during what I think was a little bit of a debate yesterday between Michael Klarman and Jeff Stone over their conflicting evaluations of, or somewhat different evaluations of Brown. And that for me, what was the one thing that was missing from their discussion is that the effect, at least on the white South, apart from the backlash that Michael doesn't give Brown much credit because of the backlash. And of course, he's right that there was an indigenous movement of African Americans in the South for a decade that produced the Civil Rights Act and the Voting Rights Act. The immediate consequence of Brown, it didn't happen next year. It didn't happen for the rest of my high school or my college or my law school. And I was teaching political and civil rights in Mississippi before there was a meaningful end to segregation in the small town and rural South in the schools. And as we know, that was not long lasting. But the message was very powerful. Before Brown, the question of racial segregation was for many young children growing up just the fact about the world, like stars in night, sun in the day. Brown made it inescapably a question of debate. And I remember doing nothing but debating race and sports and girls and race and driving around in cars night after night. I know it. I can see the line in my life between Brown and being on a picket line as a sophomore in college and the upheaval that transpired. But it is true that the court's record on race has been abominable. Aside from Brown, what the court gets credit for is not interfering more than it did in Bakke, for example, just not getting in the way. And I think the court's reticence about race, if you ask the question, what would you know about race in America? If you had a lot of material, but the materials you had were the 600 volumes of the United States reports, what would you know? It would be a very stripped bare view of race in America. And it was quite intentional. In one case, with terrible facts of discrimination against a young girl, Frankfurter wrote to the opinion author saying, leave out all the facts and just address the legal question. Quote, "It does not help towards harmonious race relations to stir our colored fellow citizens to resentment by a needless recital of details, which you need not go into." So we have that in the papers, is how clear it was. Well, that leads us to my final introductory remark, which is leads into where Seth is and where the court is on race. The angriest I ever was writing something was when the court said in the Louisville and Kentucky cases, parents involved, where the court struck down very good faith efforts by both the Black and white communities in, say, Louisville, Kentucky, to strike down that some use of race in those assignments, with the Chief Justice saying, quote, and this was quoted yesterday as well, the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. That equated two such fundamentally different practices that left me, I really felt stunned by it. And I remember writing for Slate the next morning, trying to express why these two uses of race are so dissimilar. The most powerful rhetorical point the court made was to say that parents will have to tell their child, you cannot go to the school you want next year because of your race. Just the same conversation the parents would have had, exactly the same they would have had in 1954. And yet, think about the context. Think about the context of those two conversations. One of them was remembering the governor, Sanford, our great governor, talking about what it was like. He got a letter from a Black serviceman who had to take his family from eastern North Carolina all the way to Texas to see their grandparents. And what a harrowing experience it was. It was like packing, he said, for a military operation to drive across the South. And the worst part of it, the kids saw all the amusement parks that were whites only. And that happened to children every day. The conversation in Louisville would be, dear, you have to go to PS12 instead of PS10 next year because we're trying to get over a long history of what's happened with the races. And we think it's important that everybody have some experience with children of different races. I mean, those are so different that with the Chief Justice at the judicial conference for the Fourth Circuit, I can still see the look on his face. He was holding a copy of the printout because I said that the decision was everything conservatives should abhor, a form of social engineering dictated from Washington, ignoring the principle of local control of schools, sets aside the judgment of elected officials, nothing in the text of the Constitution requiring that. And it equated the well-intentioned inclusive program supported by both white and Black people in Louisville and Seattle with the whole grotesque racial oppressive practices which came down from slavery and the Black Code. So I ended by saying, and I'll end this intro by saying that the plurality opinion in parents involved was elegantly reasoned. It read as if it had been written by the president of the Harvard Law Review, but it failed the very first lesson taught to preschoolers who watch Sesame Street. Which of these things is not like the others? And so with that, it takes us up. Seth, we had a pretty good background yesterday. Erwin Chemerinsky did I know you were involved in the morning with your legal matters you're dealing with, but Erwin gave a great overview of where the court is on race, and quite discouraging when you look at the whole sweep of it. So now you are the lead counsel for Harvard University in what is teed up to be perhaps a decisive and definitive situation where the court may intervene in order to stop private efforts to help get over the racial caste system that we've had for so many centuries in this country. What is the background? This case is on a knife's edge. What do you think? Let us know what it's about and what you think the salient points are going to be for the court. You need to unmute, Seth.
Thank you, Walter. You know, you would think that since this is probably for each of us our 18th billion Zoom experience since the pandemic hit 11 months ago, that I would be a little quicker on the uptake about unmuting, but no, not at all. I just want to thank, I start off by thanking, you know, Teddy Shaw and Jack Boger and the other organizers, frankly, creators of this really remarkable conference for including me in it. And it's because I know time is short, I won't be as perhaps effusive in my expressing my regard for those two people and the other organizers, and of course you, Walter, and my co-panelists. So yes, I think one of the reasons that I'm on the panel here is my involvement in litigation, post-Bakke litigation involving admissions and race-conscious admissions. In the modern era, I was Solicitor General of the United States at the time that the Grutter and Gratz cases were being litigated, ironically by the law firm that I subsequently joined, and I was quite involved in explaining the position of the United States in that litigation, which was quite different than the position that the previous administration had taken with respect to race-conscious admissions. It's now about, I don't know, 5.5 years since Harvard University was sued by an organization called Students for Fair Admissions, challenging Harvard's alleged use of race in administering its admissions program and determining how applicants for admission will be evaluated and which applicants will be admitted and matriculate. The loss, I know that, we've already had a panel about Bakke, and I'm going to assume given the apparent sophistication of what I can see from the attendee list here, that folks are familiar with the Supreme Court's subsequent jurisprudence in this area, specifically the University of Michigan case, the 2 University of Michigan cases, and the 2 Fisher versus University of Texas cases. Bakke, of course, the great innovation of Bakke was that Justice Powell's, opinion for the court, as it happens, for himself and for the court, was to agree with 4 justices who thought that race could not be used as a factor in admissions in order to help remedy the deplorable legacy of discrimination in university admissions in the past, but agreed with 4 justices who otherwise thought the University of California program was entirely constitutional, that race could be used. And what Justice Powell pointed to and actually attached to his opinion was an amicus brief filed by Harvard University in support of the University of California, explaining what the so-called Harvard system was for taking race into account. And that, Justice Powell said, was the appropriate way to use race, which was to use race as one fact, to consider the race of the applicant as one factor among many in promoting a university's compelling interest in achieving and assembling a student body that is diverse across many generations. And that notion, since Justice Powell's decision in Bakke and since the court's endorsement of the, quote, Harvard plan, has been more or less, with some stumbles along the way and a lot of uncertainty along the way, the current state of play. And so when Harvard was sued by this organization, SFFA, 5.5 years ago, you can say it was a bold move by the plaintiffs because they were going after the hallowed Harvard plan. The lawsuit that was brought against Harvard was remarkable and remarkably unique in a number of ways. First of all, unlike the prior cases in which the plaintiffs were Mr. Bakke, I think it was Ms. Gratz, Mr. Grutter, and Ms. Fisher, that is, individual plaintiffs who claimed that on account of their race, they had been discriminated by an undue consideration of the races of minority applicants. The plaintiff in this case was an organization, Students for Fair Admissions, an organization that was created for the express purpose of filing a lawsuit against Harvard, an organization that at the time the lawsuit was filed had no members. It had a board of directors that consisted of Abigail Fisher, her father, Richard Fisher, and the the individual who had conceived of and bankrolled the Fisher litigation, a man named Ed Blum. And so there was no individual plaintiff in the Harvard case. There was just this organization. It was also the first time that the university being sued was not a state institution and therefore not constrained in its choices and the way that it exercises its First Amendment freedoms to organize pedagogy by the Equal Protection Clause. The cause of action alleged in the Harvard case, therefore, was Title VI of the Civil Rights Act. And the claim was that under Title VI, the Title VI imposed constraints and legal standards that were identical to the Equal Protection Clause, a proposition that has never been decided one way or the other by the Supreme Court of the United States, and frankly, precious few courts. The other innovation in the case was the nature of the claims that were filed. So there were 6 counts in the complaint. One count was race can never be used in considering what applicants to be admitted. That was an invitation to ignore the Grutter decision and to ignore Justice Powell's controlling opinion in Bakke and in Fisher. And the district court promptly dismissed that count by remarking that she was quite familiar with the organization chart of the federal judiciary, and that was a legal assertion that could be acted upon by the Supreme Court if at all. There was also a count alleging that Harvard was misusing race by considering the race of all applicants, not just for the few remaining places in the class it was trying to fill. That was dismissed on the grounds that that is not the standard that the Supreme Court has imposed. Then there were 3 counts that essentially were made under the Grutter framework. One, well, Harvard is using race in a way that amounts to racial balancing. That is, it's in effect a soft quota. It's using race as, quote, more than a plus factor, which is inappropriate under Grutter and Fisher. And in any event, if Harvard has a compelling interest to achieve a racially balanced, a racially diverse class, racially and ethnically diverse class, there are less restrictive alternatives to doing so that don't expressly take race into account. But then the innovation was count 1 of the complaint, which was an allegation that Harvard is intentionally discriminating against those applicants who self-identify as Asian American. And this was no accident. At the time, after the Supreme Court decided Fisher 2 adversely to Abigail Fisher and Ed Blum went on a speaking and fundraising campaign in which he said, and we introduced this as a trial exhibit, in which he said, I need, quote, I need Asians. I need to recruit Asians to be plaintiffs to show that they, like whites, are the victims of this kind of discrimination. And in the trial that ensued, I would say the claim that Harvard is intentionally discriminating against self-identified Asian Americans occupied about at least 80% of all of the testimony in the case and all of the arguments in the trial court. There were a lot of really, really interesting things about the trial, but I'll just note 2 things. One, SFFA called, the only fact witnesses it called were Harvard admissions officers, the Harvard president, the Harvard dean of the Faculty of Arts and Sciences, the dean of the college. In other words, they put on their fact case purely by calling our witnesses adversely. They did not, there was no student, Asian American or otherwise, who was called to testify. And there was no evidence, although they had thousands and thousands and thousands of admissions files that they had been able to obtain during discovery, and extensive records about the characteristics of every one of the 160,000 or 170,000 applicants to Harvard over a 4 or 5 year period, on every possible metric. They didn't introduce or suggest that the record contained a single file of a single Asian American applicant whom they claimed had actually been discriminated against. So not only was there no individual plaintiff, Asian American, white, or otherwise in the case, there was no witness to come forward and no documentary evidence to come forward showing that there was discrimination. Their entire case hinged on the testimony of an economist that they called from Duke, who, among other things, had previously written an article analyzing the results of the decision by the people of California to outlaw the use of race in considering university admissions, which their expert called the, quote, experts said had resulted in the, quote, efficient channeling of the races, which we also introduced at the trial. In any event, to make a very long story short, the district judge issued a 130 or 140 page opinion that includes about 90 pages of findings of fact and ruled for Harvard on all of the counts. The case was briefed and argued in the First Circuit. The First Circuit issued a 90-something page opinion affirming the district court in every respect, including all of the district court's findings of fact. The decision came down, I believe, in late September or early October, maybe it was November. In any event, the time for petitioning the Supreme Court has not yet run. We haven't seen a petition from SFFA to the Supreme Court. I think everybody anticipates that they will petition. I'm not 100%, I'm not convinced at all that this is a case that the Supreme Court is going to take, and it certainly is not a case that the Supreme Court should take. But there we are, and I, you know, rather than drone on, let's get to the normative discussion here. That's where things stand now. All eyes on the Harvard plan and all eyes on what we assume will be a cert petition filed within the next several weeks.
I'd like Rachel and Mario to have an opportunity to comment on what Seth said, and after that, I'll ask each of you all to speak a little more fully. But let's start by commenting any thoughts you have about Seth's intro.
So thank you, Walter. I'll quickly say thank you to UNC and to Jack and Teddy. And it's a great honor to be on this panel with heroes and teachers and mentors of mine. So thank you so much. So what the Harvard case brings to mind to me is a continuing reflection of the fact that there is an ongoing understanding that higher education opportunity is a scarce resource. And that as such, it continues to be subject to a zero-sum politics. And so having greatly enjoyed Ted Shaw's comments yesterday, one of the things he said that I think is manifested in this case is for civil rights lawyers and proponents of affirmative action, we did not love the Bakke decision and its turn away from acknowledging the effects of historical racial subordination, but we accepted it and tried to defend and use the diversity rationale as we could to preserve access to higher education. But what he noted about the sort of opponents of affirmative action is that post-Bakke, they have never stopped looking for new and innovative ways to attack the decision, including, I think, what is reflected in this case, Seth, which is that they've taken they've drawn a new page in the playbook, and it's not an individual plaintiff, and it is an organization and a type of claim that challenges a program that was itself pointed out as the model program for how to do this in the original decision. And so from Ted's point is that for them, this is, the sort of political and social and cultural interest in dismantling this will result in them sort of forever looking for a new opportunity, and one that's deeply steeped more than anything in politics. And I think with attacks on, multiple valences. So we see the Harvard case as the sort of next fight in the courts, but we haven't said anything since Bakke of the except for the brief mention, Seth, that you did of the California's turn away from affirmative action at the state level, of the states that have considered changes to their state constitutions or legislation to do away with it, including the state I live in, Washington State, with I-200, Prop 209 in California, Amendment 2 in Michigan. And so I would say there continue to be multi-pronged attacks on access in higher education and the consider of race-conscious policies, but this is just the next in a long line. I do think there are some interesting things to talk about that I'll say briefly and turn over to Rachel. One, when we talk about Bakke, and this was also talked about in Fisher by Asamudia James in her work, and she spoke yesterday, is this kind of notion of white innocence. Ted Shaw talked about nobody, seemingly being responsible for the history of racial subordination and its current impact in this country. Nobody is to blame. And so when we have plaintiffs come forward, there's this notion of white innocence. So folks not responsible for the current conditions of disenfranchised people, and so should not be deprived any opportunity. But the notion is in this, in the fair litigation, what you now have is white innocence expanded. It's not just aggrieved whites, it's aggrieved whites and selected others. And so in Angela Onwuachi-Willig's work, she talks about whites and honorary whites, right? The people from minority groups who can be brought in strategically into whiteness for the purposes of, disturbing or disrupting zero-sum politics in a way that continues racial hierarchy and disadvantage for certain groups. So the notion is we see this first sort of branching out now to include, it's not just about whites, it's white innocence covering a larger set of groups to include perhaps Asians who are being disadvantaged by Harvard. And I want to say, because I love the fact that Walter brought up parents involved, again, involving not only the state, but the city that I live in, because Seattle schools were also involved, because the problem is the framing that Chief Justice Robert gives in parents involved is obviously built on this notion of colorblindness being real, or now post-racialism being achieved in the United States, right? We're at the point now where race is no longer salient, and racism or race discrimination is not a problem. So any efforts at considerations of race or racial balancing are abhorrent. And so this notion that we're still considering race in higher education admissions really offends the concept of colorblindness and post-racial commitments. And so at bottom, what is sort of being brought up in these cases is a really weird equality argument where the opponents of affirmative action are, if you support equality, if you support the idea of getting beyond racism, you'd be on the side of doing away with affirmative action, which of course completely ignores both the history of race in this country and our current moment of racial division, to include what we have seen since last summer in terms of the racial reckoning we've had in and around uses of police and citizen violence on the bodies of Black and brown men and women. And so what I'll say in my last couple of moments is I wrote an article in UC Davis a year and a half ago where I was arguing we should become stridently more race conscious in our approaches to admissions because of the fact that Bakke and its progeny are likely to fail due to the fair litigation and what comes after it. And shouldn't we then at least privilege telling the true story of race subordination and disadvantage and build on a platform of asking America to actually reconcile that history? And what Black Lives Matter has done for me is to put me in the space of saying, I no longer have to make these arguments that we need a racial reckoning. We are in the midst of one, and the question is, what will it yield, right? So what Attorney General Holder just said is, we are in a moment, and will we turn it into a movement? That moment clearly suggests that there remains people who have been historically disadvantaged based on race, who continue to be locked out of the American dream, including access to higher education. And that although we can talk about merits and deserts, and I'll talk about that later, that unless we commit ourselves to addressing that history and this current moment of disenfranchisement, this country cannot move forward as a unified or united states with a hope of living up to the ideas of the founders. And I'll end on two historical notes that we should keep in context. We often make sort of a significant, and we take significant note of the fact that the civil rights movement was built on peaceful protest, and it was these peaceful protests that helped lead to the decision in Brown, and certainly were responsible for the landmark legislation of the 1960s, the Civil Rights Act, the Voting Rights Act. And so we say this peaceful protest in and around the dignity of peoples who had been subordinated could not be ignored. And that became the catalyst for a program of change to include things like, race-conscious benefits programs. But that was not the only antecedent to the changes that lead to things like affirmative action. If you remember in the late 60s, it was not peaceful protests. It was violent protests in the wake of the assassination of Dr. Martin Luther King, uses of police violence in places like Watts and York, Pennsylvania, that led us to see again that the racial strife in this country was debilitating and that it had to be met with a program of inclusion, because if we did not choose inclusion, the option or the alternative might be revolution. And so if we believe that inclusion is preferable to revolution, I hope that when we start having further conversations beyond the fair litigation and talking about race consciousness, that we tie it to this moment of understanding, a pushback against post-racialism, and one that says there still is much to remedy in terms of the lingering effects of racial discrimination. Rachel.
Rachel, you want to comment on that? And then I want to ask you about the intriguing thesis of your paper. But first, I want to see if you have any comments on what Seth and Mario have said.
Right. I have three observations that I'd like to make very briefly. One of them steps back because I too was struck by the shift to a focus on elite private institutions, not just Harvard in this case, but also Yale in a federal government inquiry. And there was a back and forth between former President Trump and President Eisgruber at Princeton. And one thing that I think is worth considering is the college admissions pool, because there have been projections of what they've called a birth dearth by 2026, which would mean that most colleges and universities are going to see a substantial drop in the number of applicants for seats in the entering class. And the one group that won't be affected are these elite private institutions, which will remain actually they're going to be even more competitive. So that's where we're going to see a lot of concerns about displacement. So already the pool of selective colleges and universities is small. And with the birth dearth, they'll get an even smaller number, and a lot of the competition will be intensified around the most elite private institutions. That, of course, from the standpoint of diversity, I think is not such an issue insofar as these institutions position themselves not just as national colleges and universities, but global institutions of higher education. So you could say, well, it's just further diversifying the perspectives that will be brought to bear. But I think that from the standpoint of equality, this global kind of regarding aspect of these institutions pulls us farther away from the justifications rooted in a domestic paradigm where we're concerned about ongoing vestiges of slavery, subordination, and stigma among our citizenry. And so I think that there will be growing tensions among those rationales if the focus continues to shift to elite private schools. The final thing that I will say is that I believe that the kind of showcasing of Asian American students is really interesting, because if you look at the general statistics, they outperform academically white students in terms of high school completion, grades, test scores, applications to college completion, and ultimately the household incomes for Asian Americans are now higher than for whites. And so that has subverted our traditional kind of hierarchy of who's at the top. And so I do think it's really interesting to see this happen, because it is in part also a reflection of global migration and kind of the growing number of Asian Americans, and we'll get to Latinos later, but as a result of immigration. And so I think that's upending racial identity and racial hierarchy in its own right.
Seth, I want to ask you a question that emerges from what they say. If and when you argue this in the Supreme Court, you're going to run into an underlying theme of that this case is about displacement of white applicants, displacement of Asian American applicants. And the question is, how does one combat that? When I taught Bakke the first year, I asked my large section, because I want everybody to think of the answer to this question. You can shout it out or speak it to yourself, but without thinking, I want you to answer this question, fill in the blanks. Alan Bakke was denied admission to the Davis Medical School because he is, and everybody says white, of course. And if you unpack that, there were 100 different reasons why Alan Bakke wasn't admitted to the Davis Medical School. There were a lot of places, let's say numbers 49 and 36 and 85, where they had higher MCAT scores. And there were other places where they had people had higher grades. Maybe some they played football as undergrads at UC Davis. The list goes on. The list goes on and on, and the list goes on and on of the 100 reasons. And then, but everybody focuses on these. And if you ask the question, I did a little research, Seth, into Alan Bakke's background to ask the question, if he had turned Black the day he applied, he would have had a good chance of getting into Davis. When he grew up in Florida, the school system he went to was described as unspeakably inferior, and not that he would have gone to had he been born Black. He would have gone to an unspeakably inadequate school, was said by a district federal judge. He was seen as the leading medical school in the area, in the region. Duke only admitted white persons to its medical school. And the list goes on and on. That it belies the fact that he would have been admitted to the Davis Medical School had he been Black. Seth, do you have any comments on their comments on your comment?
On your displacement point, it is of course true that Harvard has 1,600 spots for its entering class. I believe, during the time period that we examined, there were between 35 and 40,000 applicants for those 1,600 slots. I'm told that the number this year is something like 70,000 applicants. So we're talking, I mean, the answer to any parent's question about why my child didn't get into Harvard is no one's child gets into Harvard. And what the evidence in the case showed is that somewhere between that, when Harvard evaluates the academic qualifications of its applicants as best as it can, something close to 88% of all of the applicants that are filed with Harvard are deemed by the admissions people and by the faculty as fully qualified to succeed as undergraduates. So we have an enormously self-selecting pool. The evidence also showed in a way that is sort of remarkably powerful how having an undergraduate class that is diverse across multiple dimensions, including race and ethnicity, benefits all students, whatever their race and ethnicity is, and for that matter, the faculty and the sort of the learning environment of the school. And so while it's true that there is in essence a zero-sum game, which is there just a certain number of beds, dormitory beds available for incoming freshmen, there isn't really this sense of displacement, particularly taking into account how the admissions process works. This is not a process in which, and there was both witness testimony from present and former admissions officers about how this works. There is an admissions committee of 40 people. And over the course of months, this committee works both in subcommittees and then in the full committee of 40 admissions people and assorted faculty members to discuss every applicant that is deemed admissible on all of the merits, on all of the strengths and weaknesses of the candidates, and decisions are made by consensus in a group of admissions officers that is itself remarkably diverse. And what the statistical evidence showed is that the notion that there are, quote, unqualified, African American or Latinx matriculants being admitted is ridiculous. You don't even get to the cusp of being considered unless your application reflects multiple strengths on academics, on extracurricular, on social programs, on creativity, and that race, for example, is no more significant in the aggregate than, for example, any number of other strengths that applicants may have. And so, it is true that there are few, if any, other institutions that are sufficiently well-heeled that they can have an admissions process that includes, for weeks at a time, 40 admissions officers going through the actual admissions folders of thousands and thousands of applicants and discussing the pros and cons of using one of the precious slots. The Harvard plan really is about as far as, no, we're not going to take her because we have to take a black boy. I mean, that just doesn't exist. And even the former admissions officers that SFFA called, not a single one of them testified that they had ever observed a decision made or a significant consideration being given to prejudicing a particular applicant because of her or his race. I mean, that's, I guess, the best answer I can give.
Right. And to move this to a broader context, Rachel has a very interesting paper in which she compares the fact that the court is giving less and less deference to educational institutions, not picking up seriously on the academic freedom First Amendment aspect of Bakke, of universities to self-define themselves. The court is giving less and less deference to universities, while at the same time it's giving more and more deference to churches. And so I'd like Rachel to expand on the notion of whether the court is heading in a strange direction when you try to equate these two.
Well, thank you, Walter. Also wanted to thank all the organizers. I wanted to just start with Bakke, because in Bakke, we saw the very polarized notions of equality that have been very much at the forefront of this conference, with the 4 justices who supported race-conscious use in admissions to advance fighting societal discrimination, those who thought it was always impermissible unless it was being used to rectify the institution's own past discrimination. And as was mentioned, Justice Powell found the middle way with his emphasis on diversity, which is rooted in academic freedom and institutional autonomy. Now, that rationale was actually linked to another emerging form of institutional autonomy, corporate free speech. And during the deliberations, one of Justice Powell's colleagues, William Rehnquist, circulated a memo saying, gee, there's some interesting parallels here between Bakke's claims and the claims we dealt with in Buckley versus Vallejo. And in Buckley, we said, we're not going to crimp corporate free speech to level the playing field. So wouldn't we be crimping Bakke's liberty interests, his right to compete, if we want to use affirmative action to level the playing field? Well, Powell was one of the principal architects of Buckley. He was one of the proponents of a greater role for corporations in public discourse and politics. So it was critical to him that Bakke not undermine Buckley versus Vallejo. So that is why, when you look at how he frames diversity, the emphasis is really on the autonomy of colleges and universities. So he's not addressing Bakke's First Amendment rights, it's the universities. Now, what's so interesting about this rationale, which is ultimately endorsed by the court and expanded on in Grutter and Gratz, is that it has been largely neglected by equality scholars. As Walter mentioned, I think there's been a feeling that it was sort of a diversion from the equality rationale, and it's a kind of camouflage and not really addressing head-on issues of race. And then First Amendment scholars have also neglected the diversity rationale. Now, Walter mentioned the formalism that if you went through all the US reports, you wouldn't have a very good understanding of race. And that's been critiqued, right? Why do we equate a history of discrimination and subordination with reverse discrimination against whites? And the claim is because we have a very shallow conception of race. But there's a similar kind of formalism in the First Amendment area, which is an agnosticism about the speaker. And as a result, First Amendment scholars have not attended to why we confer this kind of autonomy on certain institutions. Paul Horowitz has argued we do it because they are First Amendment institutions that have a unique role in advancing discourse, public discourse. They are institutions like colleges and universities and churches. Now, as a result of the kind of orphaning of Powell's diversity rationale, what we see is we haven't paid much attention to the interaction of the affirmative action jurisprudence and the increasingly protective jurisprudence when it comes to religious institutions. And I think that's going to be a growing problem. Now, why do I say that? The first is the issue that Walter has already flagged. When we see the Fisher case, we see the court approaching the college and university's exercise of its discretion in crafting its admissions program with growing skepticism, a demand for more persuasive proof, a rejection of a good faith test. At the same time, the court has grown increasingly deferential to religious institutions and their claims to autonomy. Not only does the court defer to the authenticity of a religious belief, it also says it can't examine a person's conviction that a neutral government regulation burdens the exercise of that belief. That, for example, has been a kind of deference you've seen when a closed corporation denied contraceptive coverage to employees because of the owner's religious beliefs. And so the court has been highly deferential to these groups based on their autonomy claims and far more skeptical of colleges and universities also asserting autonomy claims. No one has explained the difference. The other very important development is that the court has grown increasingly receptive to an expanding notion of which institutions count as religious. I just mentioned the case involving a closed corporation where the owner said our religious beliefs prevent us from providing contraceptive coverage. Now, what's so interesting there is that that was the first time that a for-profit organization had been accorded religious liberties. As a result of this expanding conception, beyond just churches, beyond just nonprofit religious organizations that promote discourse, to now for-profit corporations, we are seeing that religious liberty is on a collision course with non-discrimination laws. We've seen that in the area of contraceptive coverage and gender issues. We're also seeing it now with vendors who say that I should not have to abide by public accommodation laws because my religious beliefs make it a sin for me to provide wedding services to same-sex couples. And the courts in those cases have in some instances said that the religious beliefs exempt these vendors from providing the services, but they've gone out of their way to say, we would not do the same if these were race-based forms of discrimination because race is uniquely pernicious. And therefore, we would not allow a vendor to discriminate on the basis of race as we are now allowing them to discriminate on the basis of sexual orientation. Now that raises an interesting problem for the universities because even if they were accorded greater deference, the court's decision-making in these religious cases continues to treat race-based discrimination as unique and uniquely dangerous. And one question is, will that be imported back into the affirmative action cases? I argue in my paper that we ought to resurrect Bob Jones University, a case in which the court, 7 years after Bakke, denied a tax exemption or upheld the denial of a tax exemption to Bob Jones University. Bob Jones had actually denied admission and expelled students who engaged in interracial relations. Why? Because they said it was against God's word. Now, the court said we have too strong a public policy to permit your religious objections to allow you to then discriminate on the basis of race. That case has coexisted with Bakke, which permits universities, including private nonprofits, to retain their tax exemptions and to use race in the admissions process in order to diversify the student body. What that tells us is that although the court says it can't tell the difference between socially desirable and undesirable uses of race, it's been doing it for nearly 3 decades by not allowing Bob Jones to engage in its form of admissions discrimination while simultaneously recognizing the value of the uses of race in affirmative action in programs like the one at Harvard. So I simply argue here that we, at our peril, ignore the First Amendment rationale because of the increasing activity in religious areas, as well as the ongoing extremely protective approach to corporate free speech, at the same time that the court seems to be retreating from autonomy for colleges and universities.
Rachel, you really called to mind the striking lack of deference that the court gives in this area. I said in jest when I was doing a moot court for Maureen Mahoney and John Payton, who argued the 2 Michigan cases, that we ought to stand up and begin by saying, may it please the court, I'd like the court to take judicial notice of the fact that Michigan, like Alabama, is a state, and that education is a traditional local function. But when Alabama gets before the court, oh yeah, we're just rolling over backwards to be deferential on all these other issues. And Mario, I want to talk about the notion of who's the most qualified. There's something that I think that you've thought about. I asked my students, again with Bakke, suppose the state got, suppose the state got a grant of $750 million to have a really enhanced law school. And you're a committee to decide who should be admitted to this class. And one argument is those with the highest LSAT scores and grade pointers. But you may think, well, listen, we're going to have such rich resources. We're wasting them on the Aquila Mars, right? He's going to come out as smart as he went in, right? Why do we waste that? And maybe they're kids that don't meet the minimum standards. But wouldn't it be rational to say we're going to admit kids that aren't that gifted because we believe we can, coach them up and add more value? But in any event, would any of these choices be compelled by the Constitution? They all seem to come to class with a background assumption that the people with the highest grades are the ones, quote, most qualified to benefit from that there's this background entitlement. They don't articulate it in terms of the Constitution, but I think you see it. So Mario and then Seth, I'd like y'all to comment on that background assumption.
So thank you so much for that question, Walter. I completely agree that, notions of merit and who deserves based on certain qualifications, a seat or a place, so pervade these conversations without any kind of critical sort of interrogation of what merit means in this context. And so I'll say very quickly, for years, critical theorists have suggested that when we talk about merit and we simply mean high grades and high test scores, what you're really tracking is the type of race and class advantage that one has had and is multiplied over time. If your parents have resources, if you're in a good school system, if you have, the best sort of teachers and prep programs available to you, you will end up with high grades, and typically you will end up with high test scores. And what we find is that these kinds of sort of privileges track along certainly socioeconomic lines and also race lines, meaning that is much more likely in this country that African Americans and Latinx students will have lower quality schools because of the neighborhoods they seem to be overpopulated in. They will have they're overrepresented in socioeconomic classes where you're not getting the SAT and LSAT training, prep courses and such, that when you, at the point at which you get to college admissions, what you have is a multiplied system of advantage that we now call merit, and we both divorce from the present sort of circumstances of the very different lives of students across race and class lines, in which we divorce from the historical antecedents that have produced systemic and structural advantages that are now built into the system. So the crits have done a great job of being very critical of labeling this objective and labeling this sort of race neutral. But current scholars like Asamudia James have also attached it to notions of white privilege. We now, what we call merit is really this expectation that because I've succeeded in the system that itself is controlled by racial hierarchy, that I deserve the benefits that come with my success, and so I should have my seat. And the privilege or expectation is so strong that it even undermines notions of merit. That one of the interesting things about Abigail Fisher, if you look at the case, is that she had lower actual test scores and grades than many of the African-American and Latinx students who were denied, but she still felt like she was entitled to a place and the class. So the notion is there clearly are issues around not acknowledging merit is tied to things other than performance. It's tied to advantages that one, is basically a beneficiary of through a happenstance of birth often. So that's one. Two, that it overlaps sort of notions of white privilege. But I think I want to quote my colleague here, my former colleague, Jonathan Glader at UCLA, who wrote a wonderful article in the UC Davis Bakke Symposium about this notion of excellence being an unstated norm that colleges use, that the court has never really interrogated as to what it means and how much deference should be given to it. And why couldn't we just decide that if we're giving away the amount of money you identify, that colleges are allowed to place other values and to place other commitments ahead of what we now understand as merit or excellence, and ask different questions. And Jonathan, in that article, asked things about what have you overcome in your life that proves that you've been able to succeed probably more than we thought you would based on the resources you've been advanced, that prove that you deserve this opportunity at the scarce resource of higher education. There's also this question, and two more. One about what are we doing societally to acknowledge and then attempt to dismantle structural and systemic forms of disadvantage? And education, we know, is one means of addressing historical structural forms of disadvantage. And why aren't we allowed to use that as a value which is served through the awarding of places without some notion of saying there's a quota or particular, a politics of each race are having to articulate some kind of specified history, but just a general understanding that that we can think of a different way to allot these spaces. And finally, I'll say, if we really take diversity seriously, one of the things we see is the diversity we have in most colleges and schools is not necessarily reflective of actually the diversity in the greater society. And you could just place a larger commitment, and Professor Glader talks about this as well, right? About saying we should have classes that reflect the greater diversity of society and think about the ways in which we could admit to service that. Now, those things have not been considered because, as Ted Shaw said yesterday, one of the things we haven't done is post-Bakke really think about all the ways we might come back at the court, understanding that in some instances, arguments that were brought forward and dismissed in the case had little evidence to support them at the time, for which we now have greater data, more evidence, more ways to think about how we allot these seats. And so, at least to your initial question, I think right now, the answer is not constitutional, but it might become constitutional if we ever move to a place where we start advancing these arguments and force the court to respond to a different understanding of merit, or actually even an expanded understanding of diversity and admissions.
That's really good. We have 3 questions here. Really, I think
Can I just comment on this for a second, Walter? Because
Sure.
I think one of the many innovations of the Harvard trial was that it involved a systematic examination of what merit is. That is, what is merit in the eyes of Harvard College in making admissions determinations? And again, Harvard is somewhat sui generis, but one of the first pieces of evidence that came in was a demonstration of the fact that given the self-selecting nature of its applicant pool, Harvard could admit multiple classes of perfect SAT test takers. It could admit multiple classes of people who graduated from high school summa cum laude. And therefore, in some ways, the least, the most ubiquitous qualification of these thousands and thousands of applicants is blinding academic qualifications. It is in some ways it's the commonest feature, and therefore is not a distinguishing factor. And Harvard is not over the past 100 years has not in any respect been attempting to admit a class of the quote smartest or most academically accomplished students. It's not trying to do that. It is trying to assemble an organic class of individuals who, as a whole, will best be able to teach and learn from each other and to teach Harvard's faculty and to emerge through the benefit of this learning from people who are diverse across multiple dimensions as the most qualified class of potential community and national leaders in the future. And once you define merit that way, it becomes the kind of the multi-dimensional world that Mario was talking about. So rather than saying, as a society, why can't we just say, well, Asian Americans are only 4% of the population, so why is it that Harvard is admitting 25% of its class as Asian Americans? African Americans are X percentage, but they're not the same percentage. Rather than having some sort of social engineering program like that, to pick up on Rachel's point about emphasizing the First Amendment, what on earth is wrong with a university trying to create the kind of pedagogical environment that I've just described in the way that I've just described it? So I think in this case, we have sort of defined through a huge amount of evidence a respect in which universities can define merit in ways in which taking account of race as one factor among many is in fact the way that merit is defined.
I would dream of that Notre Dame would announce that it has a religious commitment to overcoming 400 years of a racial caste system, and therefore it is going to take race into account, not for reasons of diversity of the class, but for a broader set of reasons, because it's a religious commitment. See where we get. And Rachel's like, we have some excellent questions, and mostly for Seth. Rachel,
can I just add just two quick things? One is the fact that you have huge amounts of evidence, 90 and 100-page opinions, is already evidence that the courts aren't deferring very much to colleges and universities, that very intrusive kind of just evidentiary process. The other thing that I wanted to say is I think it's a mistake to focus the definition of merit in the courts. I think a lot of this is going to happen outside of the courts. We just had a referendum in California, Proposition 16, to rescind the ban on affirmative action under Proposition 209. It failed by about 2/3 no vote. And what you saw was that while the African-American community appears to have been supportive, the Latino community was ambivalent, whites were against it, Asians were against it. And so we are going to see some kind of alignment of what people think should count in this process through political exercises like that. And I don't think we should overlook those dimensions as well.
I think Rachel just gave one of the best answers to one of our questions. Let me tell you how quickly what they were. Seth, I think they're mainly for you initially, but Leslie Strom wants to know, is there a way to get these issues before the courts in a context where the universities are not on the defensive? That's related to the question of how is it, let's see, question by James Dockery, how did the plaintiffs overcome the standing issue? I'm smiling because Seth had me do the standing amicus brief, or lack thereof. Because someone discussed the significance of Harvard being private when all the preceding cases are state universities. And that's from Dina Davis. From Yoshi wants to know, can you, what are the best reasons why conservative justices might vote to uphold affirmative action? So Seth, I'll give you the first cut at that range of questions.
Well, let me, I'm not sure that the questions all correspond with a single answer, but for James Doherty, how the plaintiff overcame the standing issue, after we identified at the very outset of the lawsuit that we were going to move to dismiss for lack of standing, SFFA changed its rules to basically provide that any Asian American student or parent who's self-identified by like sending them an email would be deemed a quote auxiliary member. And they then claimed that they were a membership organization representing the membership organization. We pointed out in, and the district judge denied our motion to dismiss on those grounds. When we renewed our motion, we renewed the standing issue on summary judgment, explaining that, you know, these people were members in name only. They then changed the rules to point out that they now required members to pay $5 or $10 in dues. And they had expanded the board from Mr. Fisher, Ms. Fisher, and Mr. Blum to be 5 people, one of whom would be a quote, an auxiliary member. And we then pointed out that although they claim they had 37,000 members, a look at their tax form showed that 99.99% of all their revenue funding came from conservative ideological organizations, and there were only a handful of dues paid. And the court rejected summary judgment again. Walter filed a very powerful amicus brief on the standing issue, you know, which we have preserved all the way, you know, which turns on how one reads the Supreme Court's decision in Hunt versus Washington Apple Commission. To Buck Goldstein's point that, and this does sort of tie in, SFFA then turned around and sued UNC of all places, which is a public institution, again, going to the question that Dina Davis raised. And the suit against UNC doesn't involve the sort of Asian issue. This is pure overrule Grutter, overrule Fisher, or in any event, UNC is using race in a way that's not consistent with those cases. The UNC case has trailed the Harvard case, so it has been tried recently. There's no decision yet in the case. There was some thinking that, you know, perhaps the two cases could catch up to each other and come to the Supreme Court at the same time, but that really doesn't seem feasible. You know, to Leslie's question about, is there some way to get these issues before the courts in ways in which universities aren't on the defensive? It's a great question. I must say, off the top of my head, I can't think of a way that, you know, there would be a case, or that a university could articulate a case or controversy. And generally speaking, I will say that universities and colleges, the last place and last thing in the world they want to do is raise their head out of the foxhole to say, hey, we're also using race as one factor among many, and aren't we allowed to do this? I mean, this is like, there is a reason why, you know, although there were dozens and dozens of amicus briefs filed in the case, we did not have a lot of individual institutions saying, hey, we're doing it too. This was mostly associations, including, by the way, many Asian American associations saying, what are you talking about? We're advantaged by a system that takes account of our ethnicity as one factor among many. You know, Urav Joshi's question, like, about what is it that will appeal to conservative justices about our position, I'm gonna demur on, because the court may well grant cert in this case, and my practice is to reserve my advocacy and and answers to questions and cases that I am litigating to the court. I would love to hear what Rachel and Mario think about this, or Walter, but I'm not gonna reveal the secret sauce at this point.
Well, I do have a thought about that, and that is, I think that the conservative justices are liberty justices.
That's a great way to end, because whether they have any.
Oh, okay.
Go ahead, Rachel.
Okay, just
Our time
quickly.
is up, but I want to hear your answer to this.
Okay, my sense is that the conservative wing of the court is liberty focused, far less equality focused. And their commitments to autonomy for religious institutions, for corporate free speech rights, that one of the most powerful mechanisms to bring them on board is to suggest that rejecting autonomy for colleges and universities will undermine their jurisprudence of corporate free speech and religious liberty, where they've been extremely aggressive. And I think that was true from the time Bakke was decided. That Bakke was very careful, Justice Powell, to make sure that they didn't undermine the autonomy they were creating for other institutions. I see no rationale for saying that for-profit corporations are more important to public discourse and have a greater stake or claim to autonomy than colleges and universities. So to me, that's a very powerful argument for the conservative wing of the court.
Maybe, Seth, you should open by saying, may it please the court, I would like you to take judicial notice of the fact that Harvard is a corporation. And you love them. You love them. Alan, are you going to call time on us?
Yes, that was such a rich discussion. I'm sorry that we have to put it into such a rich panel. Thank you for all the insights that you all shared. You have all been a part of this fight for a long, long time, and we are so lucky to have the benefits and the just nuggets of your insights and lessons learned. Thank you, Professor Dellinger. Thank you, Dean Moran. Thank you, Dean Barnes, and thank you, Mr. Waxman.